FORA.tv. The world is thinking.
One of the things that we did was we called one of the official proponents of Proposition 8. They had listed the official proponents on their witness list, but we didn't think they were going to call them. And we went first, so we had to call them if we were going to hear them. And so we subpoenaed one of them. And what happened after that was interesting. We subpoenaed Dr. Tam, who was one of the official proponents. And the first thing that he did after he got the subpoena is he tried to withdraw as an intervening defendant, because he thought that if he withdrew as an intervening defendant, we wouldn't be able to call him as a witness. Judge wouldn't let him do that. And so we put him on the witness stand, and we went through the kinds of things that he had said and sponsored during the campaign. And the reason it was one of my favorite moments is because what you saw at the trial was a constantly shifting ground as the proponents tried to find some argument that they could stand on. And those of you who remember the campaign remember that it was protect our children. It was an argument that essentially said, we don't want our children to learn that gay and lesbian marriage is okay. And they had these ads about these horrified parents who were supposedly sort of driven to sheer terror by the idea that their child came home from school and had the idea that it was all right for gays and lesbians to be married. And when they got to trial, they tried to distance themselves from that message. And they tried to say, well, the thing that is supporting this is not sort of fear. It is that marriage is supposed to be for procreation. And if you don't have people of the opposite sex, they can't just between the two of them procreate, and so they shouldn't be able to get married. Now, one of the things the judge did entirely on his own is he noted that he'd married, like a month earlier, two people well into their 80s. And he said, I don't actually think that they were planning to have children. Perhaps even more to the point is that the Supreme Court had already faced this issue in the Missouri case that I mentioned. If you can't have physical contact, you can't procreate. And the imprisoned felons in the state of Missouri don't get any contact with anybody, let alone members of the opposite sex. So this was something that simply didn't sustain any support in terms of the law or the facts. And then they were sort of driven to another level, which is to say, well, somehow this is going to undermine the institution of marriage. Somehow people are not, straight people aren't going to want to get married if gay people can get married. Now, they never had an explanation as to why that was true, and finally they admitted even that they didn't have any evidence for. But that constantly shifting ground, I think, really demonstrated the lack of support that there was in any area for this kind of proposition. And Dr. Tam was Asian American. And one of the things I asked him is I reminded him of the really shameful history that California has in terms of discrimination against Asian Americans. And there were actually laws less than 100 years ago that prohibited Asian Americans and Caucasians from marrying, and if they did marry, they lost various property rights. And I asked him how he would feel today if the state of California was telling him how and he could get married and to whom he could get married. And He said he wouldn't like it, but he also said didn't change his mind. And I think that in some senses that too was one of my favorite moments, because it showed the extent to which certain views are beyond reason. And I think that it says why you need to have constitutional protection for minority rights.